Hi, I'm Sarah Borders with Benefits Compliance Solutions. On March 30th, Judge Reed O'Connor issued a ruling that basically took out parts of the ACA's preventive care mandate. It did not apply to all preventive care services that must be covered with no cost sharing to individuals who are enrolled in the group health plan. It only applied to certain types of preventive services. Specifically, this ruling vacated or removed all of the treatments that are recommended by the United States Preventive Service Task Force that are rated with an A or B rating. So essentially what that means is there's certain services that are given this A or B rating by this group of volunteers, and they are then required to be implemented by group health plans and covered with no cost sharing to the individual. So there must be zero cost to the individuals that are enrolled on the plan. So this particular ruling says that plans don't have to cover these because of the nature of the appointments of these individuals on this task force. So it doesn't apply though to immunizations or some other child screenings that are recommended by other governing bodies that make recommendations. Now it does also specifically say that employers that cover employers do not have to cover PrEP, which is a medication that prevents HIV. So this particular ruling says that the plaintiff's rights under the Religious Freedom Restoration Act were violated by making them cover these HIV treatment costs and making them with no cost sharing to the individuals. This in all likelihood will be appealed by the administration and other agencies, other parties. So we definitely haven't seen the end of this yet, but essentially what this means is employers could technically remove these particular services from being covered with no cost sharing if they are self-insured particularly. Now, fully insured carriers likely would not remove these particular treatments as preventive care because for a number of reasons. Their insurance contracts run to the end of the year. They already covered them prior to the ACA, and a lot of state insurance law requires that these particular types of screenings be covered. So we are likely not to see a lot of action as it relates to changes made within group health plans, especially if this is challenged and this ruling is overturned in another higher court. So best to take a wait-and-see approach on this particular issue. It is interesting, an interesting development, but as we've seen with other challenges to the ACA, they don't always stand. So let me know if you have any questions. Thanks so much for watching.